Good morning, everyone, and welcome to the first of what will be two risk reduction, risk management classes in July. This first one is going to be on the latest revisions to the RLA, the Residential Listing Agreement. And a week from today, we'll do the latest revisions to the BRBC, the Buyer Representation and Broker Compensation Agreement. As some of you and probably all of you are aware, at the last minute, Carr pulled the release of all the forms that had anything to do with cooperative broker compensation. They took a second look at it. They got input from everybody, including, I think, the DOJ and the Consumer Federation of America. They took a hard look at the status of the commission lawsuits and some of the settlements and court decisions, and decided to remove broker-to-broker compensation from any Carr form. That you'll see that today. So I want to go through the form again so everybody has a good foundation on how that works. Although it's not yet illegal, Carr has recognized that any prefixed broker-to-broker compensation will probably be eliminated as a result of the various commission lawsuits, many of which are still in play. There's only been a few that are settled, and I don't think any settlements have been finalized. So Carr's looked at the commission lawsuits, the potential future settlements, and various court decisions, and made a determination that the wave of the future is the elimination of pre-established broker-to-broker compensation. If you think about it, folks, keep in mind the real estate industry was sued in multiple lawsuits. The most famous one that we are dealing with the NAR settlement over was the Sitzler-Burnett case. And we were sued for the collusion of fixing prices in violation of the Sherman Antitrust Act. And the principal argument that the plaintiff attorneys made was that the pre-establishment of buyer agent compensation in places like the MLS or just in general was in fact colluding to fix prices. And to be guilty of this collusion, here's what a lot of us had come to realize. It seems sort of unfair, but let me just touch on the law a little bit. To be guilty of this kind of price fixing collusion, the plaintiffs did not have to prove that we actually all got together in smoke-filled rooms and discussed fixing the commission. That did not have to be proved. And that is, of course, our frustration is, we never got together and fixed these commissions. So what did they have to do? They simply had to show that offering a predetermined specific commission had the per se effect of fixing commissions. And it's hard to argue against that. Obviously, we didn't succeed in arguing against it because we lost the lawsuit. So in spite of the good intentions of the real estate industry to create a cooperative work environment where we offer compensation to other agents to help us sell our listings, you sell my listing, I'll sell yours. We were not allowed to bring that into the court, that the intent and the practice was really a practice of cooperation. Again, all they had to do was prove that the per se result of putting compensation in things like the MLS had the effect of fixing commissions. And so any preset broker-to-broker compensation runs the risk of continuing to be called out for a violation of the Sherman Antitrust Act and to precipitate more lawsuits. So Carr made probably the the best decision possible under the circumstances, the current environment, and decided to eliminate it. So you're going to see that. I'm going to start my presentation now, open up my presentation. I'll walk you through the RLA and some related forms, and you will see that. So let me share my screen. I think I can do this still. Everybody see my screen?
Yes.
There's my puppies. All right, let's see, slideshow. There it is. All right. So, of course, everyone knows by now how to reach me. Best during business hours, call my direct line. They're in red. If it's after hours or evenings, you can either email me or text my cell phone. If you call my cell phone during business hours, I will eventually see it, but I don't monitor that nearly as closely as I do my landline. So that's why I break it up this way. But if you're working, my intent is to be available to you as much as possible. And so don't hesitate to call me. And evenings and weekends is fine. Just text my cell. It's the best way. I don't keep the ringer on as a rule. All right. So the new residential listing agreement and some related forms, and we're looking at the July 24 release. And in fact, the forms were released this morning. Your handout is actually copies of the released forms. The forms weren't released till this morning, so I prepared this presentation with the red line versions, but they are in agreement, so you'll be able to follow along, I think, pretty closely. So let's look at the residential listing agreement. I'm going to skim through a lot of it fairly quickly. Want to get through all of this class in the next 40 minutes or so, and then have time for any questions. And if you have any questions at all, I want to try to help you as much as I can. So let's look at the listing contract in detail. This is the current form that is now out as of this morning. So of course it has a place to identify the seller, the broker, and the property. Now, as I said before, the biggest initial change in the RLA is the introduction of a grid similar to the RLA. And the grid puts in one location all of the basically negotiable, need to decide type terms in one spot, so you can kind of go through it and not have to look for a bunch of blanks buried within the content of the contract itself. So nothing's really changed here from the last class. The listing period needs to be specified. And again, I want to remind everyone, if you do not have a termination date on the listing period, it is an invalid contract. So be sure to have a beginning date, of course, and a termination date. From time to time, we see listing contracts with no termination date or an indefinite termination date. That's been held to be invalid. Now, pursuant to civil code, the maximum length of a listing contract, any one contract, is 24 months. And then you can renew it in 12-month segments. You can even renew it a little early, but you can never have a total duration of 24 months on the balance of the listing contract. All right. Now, paragraph 4G spells that out for you. I'm going to jump back and forth. As most of you know, this column here, paragraph column number, gives the contract paragraph that gives some detail to the terms contained in the grid. Okay, listing price, pretty straightforward. That's nothing changed there. And then specific listing types. The RLA can be used for manufactured homes. You attach the MHLA, manufactured home listing addendum, or the probate, conservatorship, or guardian probate listing addendum to this agreement. So by checking either one of those boxes, they print with the RLA, and you can fill in the specific areas in those forms. Now, the big change is in paragraph C. And of course, what didn't change is the civil code mandated statement that the commissions are not fixed by law and are negotiable between seller and broker. And then they've also added a reference to the BCA, the Broker Compensation Advisory. That is a form you're going to want to be real familiar with. I'm going to walk you through that. That has been changed with this latest revision. And so I'll take you through that. So here, the first thing in 4B, I'm sorry, C1, 4B is the paragraph. In C1, compensation to seller's broker. Only the seller's broker. Notice there's no buyer side compensation. As I said earlier, that's been eliminated. There's no place in any car form that will support that. So you're only negotiating at this time your compensation. And of course, it can be a percentage. You can add, a few dollars if you want to add it. A lot of people do that, to cover a TC fee. Don't name it as a TC fee. Just put in, 2.5 or 3% plus $500 or something like that. Or you could have a fixed dollar amount, or you can have a schedule, and the purchase price percentage is based on the listing price initially. I'm sorry, the listing price is, the percentage is based on the listing price initially, and then is ultimately based on the purchase price. Kind of scrambled that up. Hope I didn't confuse anyone. Okay, now compensation to broker is covered in paragraph 4B. In C2, there's an option for additional compensation to the seller's broker if the buyer is unrepresented. This is not a dual agent compensation. If you have dual agency, you're going to have two contracts. You're going to have a listing contract, this one paying you a specific commission, a dollar amount, as the seller's agent, and then you will have a BRBC paying you a specific dollar amount as the buyer's agent. So that would be two separate commission agreements, each paid by, or each respective principal responsible for it. On the buyer side, the buyer can ask the seller to pay it, and we'll talk about that in a minute. So, but there is an option for the listing agent to be additionally compensated if the buyer is unrepresented. The concept is you're going to work a little harder, you're going to spend a little more time, you're going to have to visit the property more often when the buyer goes to the property. You don't normally do that when there's a buyer's agent and a listing agent. But when you're the only agent and you're not representing the buyer, in other words, the buyer comes to you, does not want to sign a buyer-broker agreement, wants to represent themselves, maybe they're an attorney, maybe they're experienced, maybe they think they'll save some money. That probably has happened in the past 2 or 3 times a year that I'm aware of. I've been called, hey, I've got a buyer, they want to buy it, they don't have an agent. What do I do? Well, that's perfectly legal. And the form allows you to be compensated if you choose to by checking this box, and then you get additional compensation. That's not the total percentage. That would be an additional. So let's say you listed it for 3%, and then you wanted an extra 1%. If the buyer was unrepresented, you put a 1% here. When the unrepresented buyer bought the house and closed, you would get a total of 4, 3 for the seller side transaction, and 1, the seller side compensation, and 1% for additional compensation because the buyer was unrepresented. Okay, there it is, optional compensation discussed in detail there. C3, very important clause. They've finally given this a name. Old timers, we tend to call this the protection period. This is now called the continuation of right to compensation, or the continuation period. So if you want to reserve the right to be compensated if the seller sells the home to a buyer who's either entered the property or made an offer during your listing period, even after your listing expired, you can reserve the right to be compensated in those circumstances. Now, for that to happen, you must put a days in here. You could put in 180. That's what I recommend as a minimum. You could probably get away with 365. I think more than that's going to be a lot of pretty hard to defend, but certainly 180 days. So if a buyer doesn't buy it, your listing expires, and then a month later the buyer decides to buy it, and that buyer saw that property, entered that property, or wrote an offer during the listing period, you would be compensated. And that is detailed in paragraph 4D2. And you see that the two provisions, or one of the two provisions that must be true for the buyer to be protected, is they had to physically enter the property during the listing period, or submitted an offer during the listing period. And of course you have to provide a list of protected buyers prior to the expiration. Seller's obligation to pay previous brokers. You may take a listing that did expire, and that previous listing agent, they reserved a couple of buyers who saw the property during their listing period. So that's what C4 talks about. And so you would ask the seller about that, and then list the brokerage there. And then if there were any prospective buyers named, you would list the prospective buyers there. And this is detailed in 4F. All right, D1, items to be included or excluded. First is D1, and D2 is items included and items excluded. You can list those on the listing contract if you want. That's talked about there. In 5A, in D3 and D4, leased items or liened items. So this would be where, maybe the propane tanks are leased, maybe the solar panels are leased, and liened items might be there's something on the system, on the property rather, that a lien has been filed, usually a UCC lien, like solar power systems, where a seller is buying the power that the panels generated. And so that's discussed a little bit in paragraph 5B. And then finally, smart home features that you are going to include and smart home features that you are going to exclude. Not much in 5C to talk about, but it's a reference there. MLS and public marketing. The default is the property will be marketed in the MLS. That's in the RLA, this contract. It will be marketed in the MLS. Now, if you are going to exclude it from the MLS, permanently, then you would leave this blank. If you are ultimately going to market it, but you're going to exclude it for a time being, you go ahead and list the MLS. And then the exclusion is on the MLSA form, multiple listing service addendum. And I'll cover that. That's a pretty straightforward form, not a lot of change there, with one exception, and we'll talk about that. And then finally, if the seller does not want any photographs taken inside and out of their property except for whatever is required by the MLS, that surprises me, but there are a few sellers that just don't like, virtual tours or a lot of photographs being taken. So they would check this box if that's their position. Okay, and then paragraph 11A and 11B talk about that. Paragraph F, 2F. Brokers and sellers' duties. So first of all, is timing of the presentation of offers. The default is that the seller instructs the broker to present offers as they are received as soon as practical. Or you can check a box and say they'll be presented on a specific date. Or you can check a box an X number of days after the property is listed as active on the MLS. So that gives the seller an option to not respond to offers immediately, wait until a few come in. So that's pretty straightforward. 7B discusses that. Buyer supplemental offer letters, the so-called buyer love letters, buyer letters. Paragraph F2 discusses that. The default is the seller is instructing the broker not to present buyer letters. Now, you can check if the seller wants to receive those letters. All right. Now, if the seller wants to see those letters, they're acting against the the broker the listing agent's advice. Why? Because of the potential for implicit bias. And so that is discussed in paragraph 7C of your contract. So you see how this works. The grid gives you all of the negotiable terms, the things, and then the body of the contract gives you a little detail about each item in the grid. Finally, F3, investigative reports. The seller authorizes you to order reports, and the seller will pay for them. And the one that's pre-checked is natural hazard. Why is that? Because it's good practice when you take a listing to order a natural hazard report, because if you're in a high or very high fire zone, you may want to include an FHDS in your counter offer. And you won't know that even to include it. You could be a week or two into escrow and then find out. And then part of it, as many of you know, the FHDS requires an agreement between the buyer and the seller as to who's going to be responsible for bringing the property into compliance and when. And if that agreement cannot be reached, either party can cancel the purchase contract. So it's a good idea, especially if you're a seller, is to provide the FHDS with any counteroffer, so that when you go into your escrow, you know that the agreement has been reached. And we are recommending that sellers require the buyer to be responsible for any inspection and compliance issues after close of escrow. And if you have any questions about the FHDS, do not hesitate to call me. I know many of you do. I've given you all one-on-one a class. I'm happy to do it. I've got that form pretty much memorized, so you can talk to me. I could be in the grocery store and probably walk you through the form. Don't hesitate to call me. You want to know about that because you want to order the natural hazard right up front when you take the listing. Okay, that's 7E, talks about the reports. Exceptions, the ownership or title. The boilerplate says that the seller is in fact authorized, is the owner of the property, and there's nobody else who does own the property. You don't need any other signatures. However, there may be other property owners, other people whose signatures you need, and so this allows you to list them on paragraph G, 2G. If the seller intends to include a SPRP, you would check that box. That's the seller's purchase of replacement property. Yeah, I'll sell mine, Walt, but only if I can get another one. And that's this would protect the seller from not being out in the street if he can't find another house. And then paragraph I is seller opt-outs. The most common ones are the lockbox and sign. So if they don't want a lockbox, you check that. If it's tenant occupied, you probably need to check that. If they don't want a sign, sorry to hear that, but you check that box there. And that's discussed in paragraph 12 and 13. And then any additional terms to the listing agreement you could list there, and the text overflow addendum will kick in as you write in J. So that pretty much is the negotiable terms of the RLA. There's a few more provisions I want to review with you quickly. Advisories, the BCA prints with this form, with the RLA, and you'll want to review that with the seller. And the same with when we talk about the buyer representation agreement, the BCA will print then as well, and you'll want to review that with the buyer. So, that's automatic. And then if it's a short sale, an REO, a trust, or any other advisories you want to include, you can put them there. So that's what the advisories are. And then any addendums that are made a part of the listing contract. And again, this is the listing contract, not the purchase agreement, but you may have some addendum to the listing contract right away, and you could list them there. Advisory. I want to point this out again. This is something we sometimes forget. Agents sometimes forget this, but Civil Code, DRE, both state that any compensation paid to a real estate agent, broker, company is in fact commission, with the exception of a dollar for dollar reimbursement. It's you're not allowed to make a profit on reimbursement. So you pay for the plumber to fix the leak because the seller's out of town. You can be dollar for dollar reimbursed. You can't charge 10% on top of that. That would theoretically be part of your lifting service if you're inclined to do that, and not be a fee for service add-on. So any dollar amount is in fact, any dollar amount paid to you is in fact a commission. And then deposit. The contract says that you're authorized to accept deposits. If you're reviewing this line by line with the seller, tell the seller you are not going to be accepting deposits. We don't want to get involved in trust fund management. So the contract allows for the money to be wired directly to escrow, or the buyer can take it, a check directly to escrow. That's part of the RPA. So 8 will not apply. And it's not that you have to. It says that the broker's authorizing you to. Just tell your sellers that you won't be accepting deposits. So the buyers will be making that deposit directly to escrow. Mediation, I get a question on this from time to time. Arbitration is offered in any buyer to seller contract. We want to be able to tell the buyer or the seller, if you guys want arbitration, then you can initial a paragraph and it'll be included. Arbitration is not included in any broker principal contract. So the BRBC does not have arbitration. The RLA, as you can see here, does not have arbitration. You do not need to initiate initial mediation on any contract. Mediation is boilerplate in all contracts. There are many brokerages, this one included, that are not necessarily fans of arbitration. There are some drawbacks to arbitration. The biggest one relative to the brokerage is if we're sued by a buyer, and because something wasn't disclosed to the buyer, we didn't do our job according to the buyer. Of course we did. You're all great agents. You guys are phenomenal agents. I can't think of a better group of people. I work with a lot of agents on the other side, don't know what they're doing, quite frankly. I don't have many agents in this company don't have, all of you are on the ball. So but that doesn't matter. You still get sued, right? Well, maybe we want to bring the home inspector into this lawsuit because we think the home inspector screwed up. Arbitration, you cannot do that unless the home inspector has pre-agreed to arbitration. Well, we don't even have a contract with the home inspector. So we're precluded from bringing him in. So now we'd have to file 2 actions, So with a lawsuit, we could cross sue somebody else. You can't do that with arbitration. So that's the number one reason why the brokerage doesn't like it. There are other things too. Arbitration is not appealable unless there's a procedural error. But if the arbitrator makes a mistake on facts of law, too bad. You can't appeal it. No, you don't understand the law. I'm going to go to appellate court. They'll understand the law better. Civil courts get appealed all the time, and appellate courts correct civil courts. No, you didn't get that right. It should be the other way. Can't do that with arbitration. Anyway, didn't mean to go off on the tangent here, but I just want to point out, we don't have arbitration in contracts with principals. You should not recommend arbitration. You should not recommend against arbitration. You should tell the client that's a decision they should make. There is a CAR bulletin that I have edited just a little bit to make it a little user-friendly, and that is in Agent Hub. So have that handy whenever your client says, what about arbitration? Should we initial that? You shouldn't say, yes, 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 that's a good idea. You shouldn't say, no, 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 Walt doesn't like it. You should say, let me send you a little bit of an explanation about it. You might want to check with your legal advisor, but this explanation gives you both the pluses and the minuses of why you would or wouldn't want to do arbitration. Okay, but mediation's there. All right. And then finally, entity sellers is a place for that to be handled. So an RCSD is sort of built into the form, and then place for the seller's signature and the broker's signature. That concludes the RPA. I'm going to go through the other forms, and then we'll collect all the questions if we have any. Maybe we won't, but if we do, that's great. We'll cover them all at the end. So let's talk about some of the related forms. The first one I want to talk to you about is the BCA. And you can see this red line version. It's been out since May, and it's been extensively revised since the May version. So the version that was out this morning, the one that's in your handout, is the correct latest version. And again, one of the principal features of the revision was to remove any reference to co-op compensation. So let's look at this is a great form. This is a nice form, especially paragraph 3, which we'll look at in a minute, to explain to both buyers and sellers how buyers agents can be paid in this new real estate environment. All right, so paragraph 1 is mostly directed to sellers. That doesn't mean you wouldn't review this with your buyer, because the buyer should understand what a seller's obligations are that might impact a buyer's decision to ask the seller to pay for the buyer's agent's commission as well. So paragraph 1, like I said, it's directed toward the sellers. 1A talks about the commission being fully negotiable. As you've noticed, that's all over the paperwork. One of the lawsuits, the Sister Burnett lawsuit, they successfully alleged that they did not know commission was negotiable. I don't know about the state of Missouri, but I don't think you can make that argument in California. Okay, then it talks about the optional additional compensation. So here's a little more detail when the buyer is unrepresented. And again, this is not dual agency. The buyer is coming to you, you don't want to represent them, or more probably, they don't want to be represented, because if they're going to be represented, someone's got to pay. And no, I don't need an agent. I can do it myself. Well, not sure I'd agree, but every buyer has a right to buy a house without an agent. So if a buyer's coming to you unrepresented and the seller wants to accept that offer, this is the discussion of what the agent would have to do, the listing agent, in working with an unrepresented buyer. And it talks about the fact that you're going to execute a buyer non-agency, BNA, with that buyer. Very important to do, because what you're going to be doing is you're going to be giving paperwork directly to the buyer. You're going to be answering questions for the buyer. That's fine. You can answer a question. You cannot give advice. How you inadvertently assume agency is to tell the buyer what they should do, what they could do, that sort of thing. If I tell somebody that I don't represent that the roof's 10 years old. And why do I say that? Because I have proof that it's 10 years old. I don't want to be responsible for the roof if I don't have proof. So let's say I have an actual copy of the roofing contract and the roof was put on 10 years ago, and the buyer says how old the roof is. I can answer that question. And that does not assume buyer agency. The minute the buyer says, do you think I should have the roof inspected? You answer that question, you have just assumed agency. So your answer would be, well, that's your decision. I don't represent you. I can't give you advice. And again, this is a buyer who's elected to not be represented. Okay, now, 1C also talks about dual agency, where in fact a buyer and a seller are represented by the same agent. And it makes this point that the possibility of dual agency exists because the same brokerage may represent the buyer and the seller. So different agents may work with the buyer and seller, but both agents represent the buyer and seller. So whenever you have a dual agency, I hear this from time to time, please don't do that. A listing agent will say, okay, this is a dual agency, but I represent you and Brenda represents the buyer. No, the minute you use the word represent, you need to say, I represent both you and the buyer. Brenda represents both the seller and the buyer. You can say works with. So yeah, this is a dual agency. I'll be working with you. Brenda will be working with the buyer. Sorry to pick on you there, Brenda. Your name just popped into my head. I don't know why. Okay. So keep that in mind when you are a dual agent. Be careful not to deny dual agency. Okay, paragraph 2 concerns buyers. And so again, buyer representation compensation is fully negotiable. And the requirement for a written agreement. Currently, the NAR settlement will require written agreements when any agent works with a buyer. Ultimately, prior to showing a buyer residential property or giving a buyer a tour of a property. Ultimately, civil code will require that. The legislation's been drafted, and they expect that to go into effect January 1 of 2025. And the advantages of a written agreement, of course, with a buyer, California, we traditionally don't have buyer representation agreements in the past. So that this was put in there to sort of, ease people into both agents and buyers to, this is a good idea to have a representation agreement, where in some states it's been required for years and years and years. And a buyer wouldn't even think, well, wouldn't even question the need to have a written agreement. That's the way real estate is done in that state. It's going to be done that way in all states, and many more states will probably make it a state law as well. Okay, paragraph 3 is the one going to be most helpful, and that is, when a buyer signs an agreement with an agent to represent them, and agree to pay them money, the person responsible for that payment may be negotiated. So the BRBC, as you will see next week, requires the buyer to be responsible for the payment, but there's lots of different ways that payment might, well, not lots, but there's a few different ways that payment could be made. So paragraph 3 discusses that in some detail. It's a great form to review. One of the things in these revisions, Carr made the forms a little simpler, a little easier to read. I noticed, I was talking to Lindsay, there's a lot more white space on these contracts than the past. You probably noticed that if you looked at your handout. So these are pretty straightforward, consumer-friendly forms, and this is a nice way to explain to the buyer various ways that the buyer's agent could be paid. So one way, of course, is the buyer pays, just pays it outright. I'll pay it when escrow closes. I made a lot of money on a sale of my home. I don't need the seller to help me out. I'm going to pay it. So that's 3A. 3B is the seller pays. And if the seller pays, one way is for the buyer to negotiate for the seller to compensate the buyer's broker. And the buyer is negotiating that. I think I said seller, I'm not sure. The buyer negotiates for the seller to pay that. So they can make that as part of their offer, that the buyer agent be paid by the seller. The buyer's agent could negotiate directly with the seller if the seller's unrepresented. And so, you have, that's sort of like a FSBO. That's not unlike the way you've handled FSBOs. You'd talk to the seller and say, I have a buyer who wants to buy the home. He has an obligation to pay a commission. Would you pay that commission on his behalf? Would you pay me? And you can do an SP. So the seller's paying the buyer's agent directly without that being a part of the purchase agreement, and you would use the form SP. And of course, you'd use the seller non-agency form if, in fact, you were only representing the buyer in that situation. And then a final statement just to sort of tell people, because, we're paying attention to this. It's on our radar, of course, never far from our mind. But the typical buyer and seller, there are people out there that, have heard a little bit about it, but not much. And there are some people who haven't heard anything about it. So paragraph 3C sort of does say, historically, the MLS has been a place where buyers agents were compensated through the MLS, but that is going away. That won't happen anymore. And so that just talks about the changing practice. The NAR settlement prohibits paying a buyer's brokers through the MLS. And I find that buyer, or either one, because this form's the same form for the buyer or the seller. So whichever principal signs it, and that's done. Now, the cooperating broker compensation agreement, it's going away. It's gone. It's not in the library now. Don't use it if you have an old copy. This was to adjust cooperating brokerage, cooperating commission, a broker commission through, what's offered in the MLS. You want to change it, or something wasn't offered in the MLS, and you want the listing agent to be responsible for it as a part of you representing the buyer. So don't use this form anymore. Unless you saved the copy, you're not going to use it because you can't get it. All right. The residential purchase agreement, we talked about the seller could pay the buyer's agent on behalf of the buyer. So how does that work? As most of you know, in the RPA, page 2, paragraph 3G, I'm going to talk about G1 and G3. So first, let's talk about G3, and this is where the seller agrees to pay the obligation of the buyer to compensate the buyer's broker, and that obligation is in a separate agreement, which is the BRBC, and you include the car form SPBB. It's been simplified. I'll take a quick look at that with you here in a minute. The other thing I want to cover, this is something you may not be aware of. 3G1 is for seller credits, and the reason 3G1 exists as well as 3G3 is you want to separate seller credits for anything other than the buyer broker from the seller credit to pay the buyer broker. Why? Because lenders have determined that they will not count compensation that the seller pays for the buyer's broker against the allowable credits that a seller can pay. So let's say you have a loan program that only allows a 3% credit from the seller to the buyer, and this buyer wants 2% credit for closing costs and wants the seller rather, to pay his broker, which is 2.5%. Well, 2.5 and 2 is 4.5. Maximum credit allowed by this loan program is 3. So they're going to waive off the 1.5, and the buyer would have to come out of pocket for that. So the way to do that is you would put the 2% on G1, and the SPBB, you specify, the 2.5% going to the buyer broker. You separate those. So that's the purpose there. Hope that's clear. If you have any questions, call me. That can be critical if you are asking for any credits other than paying for the buyer's broker. If you're only asking for the buyer broker to be paid, then that would be covered in 3G3. But any other credit, you want to separate that and list that credit in 3G1. Check that box and put in the amount. Now, if you do, in fact, ask for the seller to pay the buyer broker, 3G3 you check, and then you attach the SPBB, seller payment to buyer broker. It's been simplified. They did away with the math. They figured the listing agent and the seller can do their own math, and all this form has now is how much you want them to pay. So the top of the form is pretty much the same. Identify the property, who the buyer and the seller are, and who the buyer and the seller brokers are. And then the seller payment to the buyer broker. Simply specify the amount. And this amount, whatever the buyer wants the seller to pay to the buyer broker for the buyer, you put that in that amount. Now, it's important that the maximum obligation that the seller can be asked to pay is the amount on the buyer representation agreement. So if you have a buyer representation agreement for 1%, because that was easy to get the buyer to sign, you can't ask the seller to pay 2.5%. And people have talked about, well, you can always modify the buyer representation agreement if, in fact, 2.5% is available to you, because the listing agent or the seller said, oh, I'd pay up to 2.5%, no problem. You want to be very careful with that, because changing that is going to be demonstrating a breach of fiduciary duty. You're putting your financial interest ahead of the buyers because you agreed to represent the buyer for 1%. But now, because an extra 1.5% is available, the total 2.5%, you want that other 1.5%. And that could have a consequence to the rest of the negotiating of this escrow. Buyer's going to be fine with it today. Why? Because they love the house. Quoting one of the smartest agents I know, you're all smart, but this agent gave me a great quote. Everything's wonderful till it's not. So this buyer is going to say, yeah, you can have that extra 0.5%, no problem, or 1.5%, no problem. We'll amend it. And then 3 months later, when he's madder than heck about something with the house, he's going to point this out to somebody, and you're going to have a real serious problem. So you should not be listing buyers with the expectation you can bump that number up when you get the seller to pay it. That could be very problematic. All right. Got any questions on that? Ask. We can talk about it more, but wanted to cover that a little bit. Okay, representation regarding compensation. The buyer's representing that they do have a broker representation agreement, and that the amount they have to pay is no less than what they're asking the seller to pay. You may have to deliver proof of that agreement and the percent the buyer's obligated to pay, and that's done by sending the last page to the listing agent if they ask for it. You don't need to include it with an offer, but ultimately you may have to provide it. And then finally, if in fact the seller doesn't pay after they agreed to pay you, this allows the buyer's agent to sue the seller directly rather than, absent this paragraph, we would have to sue the buyer and ask the buyer to sue the seller. That's not going to be easy for us. So we'll just get permission to sue the seller directly. If after they agreed to pay us and we open escrow, the buyer's happy, and then at the last minute they renege on that and they say, no, we're not going to pay. You could still close the escrow and go after the seller for that payment. All right. Hopefully you don't have to do that. All right. Multiple listing service addendum. You'll notice, and this is a copy of the red line version, and there isn't much red on this form. In fact, hardly any. I don't think, if any. Why? Because they took most of this off of the old RLA. So there's not much that's new here, with one exception, and I'll cover it. So this used to be contained, these paragraphs used to be contained in the RLA. Since the MLS, the cooperative compensation is no longer going to be offered, they wanted to separate the MLS from the listing itself. You still put properties in the MLS, but you're not going to offer compensation through the MLS. So rather than modifying all of that in the RLA, they just made a separate form for the multiple listing service addendum. But it's all the details of what you're already familiar with. This is pretty much the same boilerplate that's been in the listing contract for years. Everything from clear cooperation policy. By the way, that's under attack, and NAR has indicated a willingness to let that go. So, I'll keep you informed, but clear cooperation may be a thing of the past. I don't know how soon, but that's the latest thing that's being attacked. Coming soon status talks about that. Nothing has changed. Okay. When you're going to begin marketing, check the box, fill in the dates, pretty much the same. Now, the one thing I want to just remind you, currently the clear cooperation policy does exist, and it exists with all of our MLSs that we subscribe to. So do not check F thinking you have some kind of option that the seller can say, you don't have to do clear cooperation. It's not optional. So don't check F that, even though, the reason that's on there is there are some MLSs that do not subscribe to clear cooperation. They're none of the major ones. There are little small markets, not too many, but they exist in California. So they had to put this in there. All right. MLS data in the MLS, again, all pretty much straightforward. Now, the thing that's new is seller concessions. And they talk about seller concessions, and I'll walk you through that real quickly, Concessions are monetary payments that the seller agrees to make toward the buyer's expenses and other costs. The concessions may include escrow, title, and the buyer broker fee. They cannot, by the way, be limited to that. Any reference that concessions must be used to pay the buyer broker is illegal, and any reference that you will only pay concessions if the buyer is represented is illegal. All right. Concessions can be identified in the MLS. They are not promises to pay. They're an offer. So when a seller says, I'm offering a 2.5% commission, a concession, and the buyer's agent says, oh, great, I'm going to use that concession to pay my agent. If the RPA doesn't include the payment of that 2.5% concession, it doesn't exist. You know, it's just like personal property in the MLS. That's an offer. I'm willing to leave the refrigerator. The fact that it's in the MLS is not contractual. You need to make it part of the contract. So concessions are an offer, not binding on the seller. And it talks about that there. All right. Seller's authorization. Here's where you put it in the, put the concessions in the MLS or not. The boilerplate is that the concessions do not go in the MLS. Carr told me the reason they made the boilerplate no concessions in the MLS is some MLSs don't allow it. And so they didn't want agents to inadvertently be bound to put concessions in the MLS only to find out it's not possible. So if we can put concessions in our MLSs, but we need the seller to check this box and authorize it for us to put concessions in the MLS. Again, concessions are not a dollar amount, and they are not to be named for what they're for, other than buyer expenses. If the seller wants to make it a dollar amount, the seller needs to email you specifically what that is. You've got to have a paper trail that the seller says, I want that dollar amount in the MLS. I'm not sure the MLS will even allow you to put the dollar amount in. But okay. That's pretty much it. That's the MLS. Let me talk about the two modification of terms paperwork, and then a real simple open house form that listing agents can use. So the first one is the disclosure and modification of a listing agreement. You do not need this form for any listing you took this morning or thereafter. This form is for listings you took yesterday or any time before, because yesterday and any time before you used the old RLA and it had information in there about buyer's agent's commission and a listing agent's commission, and it had information about MLS cooperative commission to be put in the MLS. So all of that is going away. I'm not sure when San Diego MLS is changing, but I am told the CR MLS is changing August 13th. Everybody has to change, I think, August 17th. So San Diego MLS will probably change sometime in early August. And you won't be able to do the things that you can do now with your old listings. Right now, you got listings with cooperative compensation in the MLS, and they'll stay there until the MLS eliminates that field, not later than August 17th. So you want to amend your listing contract because the listing contract says you're going to do that, but you can't after the 17th. So, you identify the broker and the seller. It's intended for use with the RLAs that were, the latest revision was 12/23. So the RLA that was in service yesterday, the revised date was 12/23. Any earlier version or the one for 12/23 would be what you use this for. And it talks about offering compensation in the MLS is going to no longer be possible. And so you need to modify this agreement because you're not going to be able to do it. Now, the modification of listing agreement also includes, your old listing agreements broke up the commission between how much you were going to get and how much you were going to put in the MLS. And so the boilerplate says that the seller and the broker agree that the total compensation shall be reduced by the amount authorized to be offered in the MLS. So that's the term I use, is bottom blank. I forget what number it is, but the bottom blank on the front page of the old RLA was the commission you put in the MLS. So the boilerplate of this modification says that will go away, and the compensation the seller owes is simply not the top commission, because the top commission was both how much the listing agent was going to get and how much the buyer's agent was going to get. So the total compensation will be the total compensation with the amount authorized to be put in the MLS subtracted from that. That's the boilerplate. Or you can check this box. Good luck with that. And no, the compensation is going to stay the same, and you're not putting anything in the MLS, and you no longer have any obligation to offer the listing agent that compensation. So, all right, that. Now, the other modification terms is pretty much like the old one. It looks pretty similar, and this would be used for any RLA from today going forward. And it's pretty straightforward. Not much has changed. Listing price is, there's a boilerplate where you can change price. There's a boilerplate where you can change expiration date. But again, you cannot have an extension of more than 12 months if it's residential, 1 to 4 units. And finally, there's a place to set compensation. Those are the three things usually. Most of the time you need to generate an MT4, and then if for anything else you have an other overflow addendum will work, and you fill that out, and then principal sign it, the agent signs it. Now, the only last form I'll cover real quickly, and we'll open it up for questions. It's real simple, and that's the open house form. I covered that in detail before. That has not changed, with one exception, and only one exception. They numbered the paragraph. You'll see what I mean in a minute. So the open house visitor, non-agency disclosure, and sign-in, that form was created to help you document that people who are visiting your open house and not signing a buyer representation agreement understand that you don't represent them, that you are functioning as an agent for the seller. And they made this sort of like a sign-in sheet to make it simpler. What Carr will say is, we understand that agents use sign-in sheets at open houses, so we simply put this verbiage on a sign-in sheet, and now you've got a sign-in sheet for the visitors, and you don't need every visitor to sign it, just the principal visitor. So if a family comes in, just one member of the family, the ultimate person who might be the buyer of that property, they might be the ones that sign it. And so again, nothing's changed here. This is what the old form looked like, with the exception there was a 1. I'm sorry, there's now a 1 in front of visitor intends to view the property. A 2 in front of agent does not represent visitor. Communication with open houses for the benefit of the seller. The communications with the agent are not confidential. By the way, fiduciary duty has attached to it, communications are confidential. So if you're not an agent of the buyer and the buyer tells you something, you can share that with the seller. If you're an agent of the buyer, you may not be able to share that with the seller, and if it's questionable, you'd have to for sure have the buyer's permission to do that. If the visitor writes an offer, then they're going to have to disclose that the agent's broker represents the seller, and may or may not represent the visitor. And if the visitor wants to be represented by the agent, of course, it actually doesn't represent the visitor, but unless the agent wants to be represented, then they would have to do a BRBC. Pretty straightforward. That pretty much covers it. I hope it made sense to everybody. And Lindsay, do we have any questions?
Yes. What if your buyer, while under contract, goes to an open house? Is that considered with the continuing period after listing expired?
Say that again. I'm not sure I understood what the question was. Say it. If the buyer, what?
What if the buyer, while under contract, goes to an open house? Is that considered with the continuing period after listing is expired?
Yeah, if your buyer if a buyer went to an open house while you had it listed and you know who that buyer is, and now your listing's about to expire, again, you got to give this notification before the expiration, not after. You know who that buyer is. You could list that buyer because that buyer physically entered the property. I'll tell you, that's not much different than any listing. I'm sorry, any buyer's agent who showed the property and now your listing's about to expire. If you contact that buyer's agent and say, hey, can you give me the name of that buyer? I'm not, I know it sounds like I'm going to steal them. Haha, I'm not. I want to protect you, make sure compensation's paid and myself. So I'm going to list that buyer. So that practice I've been teaching this for years and years and years because you need to name the buyer. So it's the same thing. So you're doing an open house and 3 buyers come through and you have 2 names. The other one didn't give you a name, Mickey Mouse or something like that. You can name those 2 buyers in your notice of prospective buyers and have the continuation period protect you if that buyer bought during the continuation period. I think that answered the question.
If your listing's a referral and you add in the extra amount due to corporate with an unrepresented buyer, is that extra amount subject the referral fee too, or are they calculated separately on the commission disbursement form?
Well, I didn't understand that all. Say that again.
I don't either. It's Jamie's question. If your listing is a referral and you add in the extra amount due to corporate with an unrepresented buyer, is that extra amount subject the referral fee too, or are they calculated separately on the commission disbursement form?
Either I don't understand the question, but I'm going to answer it because I think the question is making an incorrect assumption. If you want to add to your listing contract, let's say you want 2.5%, or let's say 3. That's okay. This is, well, no, 2.5%. You want 2.5%, but you have to pay 1% to the referral company. You could list it for 3.5%. Or let's say you want 3%, but you have to pay $1,000 to a referral company. You could say 3% plus 1,000. That would be on the first blank. The unrepresented buyer is simply an additional fee, has nothing to do with whether the listing's a referral or not. It's an additional fee that the seller's going to pay you for the extra work you have to do because the buyer doesn't have an agent to do the work. I'll give you a perfect example. A buyer should never be in a house by themselves. So physical inspection, the buyer's agent's obligated, I argue, to accompany the buyer to that physical inspection. Once in a while, they don't want to. They call the listing agent up. Some listing agents say, sure, no problem, I'll do it. I'm not sure that's a great idea. It's nice, it's friendly, but don't get in a conversation with the buyer. The buyer's agent should be there, period. All right. So you can say, look, I'm not going back to the house. You got to show it to the buyer's mother-in-law. You go in there. That's fine. I'm not going there. I'm the listing agent. If the buyer is unrepresented and the buyer calls you up and says, my mother-in-law wants to see the house, what are you going to say? No, you want this to close? Yeah, okay. Now you got to drive across town, extra work. So kind of a silly example, but it's real. And so Carr wisely, I think, said, look, because they believe, not a lot, but the potential for unrepresented buyers is larger now than it was prior to this all going down. Maybe once or twice a year, I get a call. The buyer's unrepresented. What do I do? I'm probably going to get a call. Well, I may not get calls. Now you know what to do. But I think that's going to happen once a month, not once a year. So the unrepresented buyer, back to Jamie's question, if I understand it, that has nothing to do with the referral. That has to do with who the buyer is. If you want to add to the compensation because it's a referral, you can factor that into your percentage, or you can make that a plus and put it on that extra blank. Does that answer Jamie's question? If she wants to log on and clarify the question. No. Yep.
Or she can write it in the chat if she wants.
Okay. All right.
Let's see. The next question is the RLA in car forms only allows a sample. I'm unable to add it to my forms. I think she means in zip form. I'm listing a home this evening. What should I do if I can't access the form?
What form?
The RLA.
No, it's your booklet. I printed it this morning.
So it
I
should be
got
in
up
there.
early
Yeah.
because those red lines don't scan well, and they work fine for me, but to make copies for you to have a handout, you've noticed that in the past it got a little bit of noise with them. So I was hoping they would release those things. I was told they were going to release them early. So the new RLA is out. Yeah.
Do offers of concession go in confidential remarks?
Well, you could, if there's no concession field, you could put it in my understanding is both MLSs are going to have concession fields. They may be waiting until they remove the compensation field. But again, if you put it in remarks, do not condition it and don't put a dollar amount. It's simply seller is willing to consider paying concessions to buyer.
What is the PSRA form?
Say that letter again.
PSRA.
That is and I'm going to cover that next week. That is a mini Neil Caden. I listened to him do a webinar. He calls it's a buyer represent. No, it wasn't Neil. It was another guy. It's a buyer representation agreement light, LITE. So it's a 3-page buyer representation agreement. It's real simple. It cannot be exclusive. It's only non-exclusive. It's for 30 days. It can be renewed. There was one drawback I did. Oh, yeah, it does not have a protection clause in it. I'm hoping to talk to Car Legal between now and next Wednesday to get an explanation of why it doesn't have a protection clause. The buyer representation agreement, the BRBC, has a protection clause or what they call continuation clause, just like the RLA has. It's like all of our RLAs have always had. The PSRA doesn't have one. So it's a real simplified buyer representation agreement. Oh, and it's for a maximum of 3 properties. It's a buyer rep form. So that'll be in next week's class. But if you have a need for it, call me now. I'll be happy to review it with you.
What happens if an agent drafted an RLA yesterday, made the listing effective in 3 days, and sent it to the seller for signature? Do they need to rewrite the RLA on the new form?
Well, do they need to? Well, yes, because if they haven't signed it, you want to use the current form. You don't want them to, if they sign the old form, here's something that, doesn't come up, but it has come up, not in our company, one of my missions that it never comes up, but, you have a E&O policy through CAR for the use of forms. So if the form is why you got in trouble because the form didn't address the issue adequately, and it was determined it was the fault, the failing of the form, we're protected. Well, one of the things is you can't use an expired form. So if your seller signs an RPA later than 9 o'clock this morning or 8 o'clock, I printed those forms out at 8, you got an expired form. Now, it wasn't expired if they signed it yesterday. So you would be covered under that policy. Now, I know it's a kind of a nitpicky point, but it kind of illustrates I would want to use the current form to the signature date. So if the seller's signing it tomorrow, I would withdraw that old RLA and replace it with a new one.
On the RLA, item number C1, do you put the entire commission percentage, for example, 5%, and then use the MT to modify C1 if the seller pays the buyer's broker?
So I'm not sure what the logic is. So you want to put 5%, or you're asking if you can put 5% as total compensation. That's compensation to the seller broker. So So what do you want to do later?
She wants to put the total 5% and then, hold on, let me find it again. Put the total 5% in C1 and then use the MT to modify C1 if the seller is going to use part of that 5% to pay the buyer's broker.
Well, I'm not sure the logic of that, though. I'm not following. So what if the seller's not paying the buyer broker? The seller going to give you 5%?
That's what
What the contract would say.
yeah.
And I'm having a hard time. Whoever that is, I don't name that person because they're going to get all kinds of calls. You can get a 5% listing. You need to do some seminars for us. But you know, you're going to reduce to 5 if the seller pays the buyer broker. But if the seller doesn't pay the buyer broker, you're going to keep it at 5. So my belief is you're at the listing presentation, I'm going to get 5%. Oh, by the way, if you're selling the buyer broker, I'll reduce it. But if you're not paying the buyer broker, I get to keep the whole 5.
I don't know if Chris wants to chime in. It was Chris Vaughn who asked the question.
Okay, Chris.
I'm going to move on. So
Okay.
Rick McCandless asks, with so much talk about unrepresented buyers, I feel there will be more that try. What is our obligation as a listing agent to work for that unrepresented buyer?
Well, your obligation to work with that unrepresented buyer is really as a result of your fiduciary duty to the seller. So I want to be careful how I answer this question because I don't want to be misquoted and I don't want to speak floppily. But you have no obligation to work with an represented buyer for the benefit of the buyer. You have an obligation if the seller, first of all, if the seller, let me complete that sentence. If the seller wants to sell a home to an unrepresented buyer, I would argue you have an obligation to do it. Why? Because you work for the seller. Now, you don't have to assume agency, but you probably do have to drive over and show the house to the mother-in-law. Not because because you're helping the buyer, because you're helping the seller. See, it's sort of a small nuance, but it's an important nuance. You don't advise the buyer. You don't assist the buyer in locating an inspector. You don't arrange for repair estimates. He does the arranging, but are you the one going over there and opening the door for the plumber to give him an estimate? Yeah, because there's no buyer's agent. So that's why, if you want to be compensated for that, and I think you can make a good case for that. If I were selling today, I don't think I'd have much trouble getting at least another % on that. And at these prices, that's not a small amount of money. And I'm not assuming any liability. I'm running over there to open the door once in a while. That's pretty good pay. You have no obligation to the buyer to do it for the buyer. You probably have pretty big obligation to the seller. See, the seller says, I don't care if he's represented or not. I want to sell him a home. He's paying me full price. He's all cash. He's removing all his contingencies in 3 days or 5 days or whatever, or with the offer. I don't know. I like this buyer.
I'm talking about the paperwork part of it, the paperwork, like the request for repairs and things like that.
Yeah.
I'm writing that up for them?
You're writing it up for the seller.
Okay.
Right. See, so what you might do, and here's that's a great question, Rick. And you're on to something, and you give me an opportunity to because you're being cautious, and you're right. No, you're not writing it up for them. You're sending them the RR and saying, fill it out. You're saying, list what you want fixed.
Lindsay, can I chime in real quick regarding that other question?
Yeah, go ahead.
Okay, so regarding I'm not trying to be greedy, Walt, with the 5%. I think I'm kind of stuck on the old RLA where the compensation to the buyer is included in the old RLA as far as the listing agent. So I'm going to I guess this is so confusing to me. So I'll put in 2.5% on C1. And then do I forewarn the seller that the buyer's broker will likely ask for compensation in the BRBC and the RP or the RPA, and just kind of forewarn them, and then they're just paying that as a concession, correct, in escrow?
Correct. And the way you forewarn them is use the BCA. The BCA
Oh, okay.
is the paperwork format that almost gives you the opportunity to explain that. You know, you
Okay.
pay me 2.5%. Now you may pay more. You don't have to, but you may, you know, and again, you want to couch that in buyer terms, not agent terms. You don't want to say, if you're not willing to pay the buyer's agent, the buyer's agents aren't going to show the house. Can't say that. You can say, if you're not willing to pay the buyer's agent, the buyer may not want to be shown the house because buyer wants his agent to be paid for him.
Got you. Okay. And
I
then
never thought you were being greedy, Chris.
He
I actually
he
thought
liked your
exactly what
style.
you said. You
well,
were-
I
you
think
were having a hard
Mike
time.
would like it. I think Mike would like it.
Yeah, well, if you could get 5%, that would, but that, yeah, that commission goes to you.
Okay.
Did we answer Rick's question? Rick, there is extra work. There's no doubt about it. And to the extent, you know, I mean, you've been around long enough and I've been around long enough. We both know you send a blank RR to a buyer, he's going to screw it all up. And that's why I would put a 1% in there at a minimum. I put something in there. You know, if you don't ask, you
It's
don't
not just,
get.
it's all the forms. It's the final walkthrough form. It's like every single bit. You're gonna be doing the whole project.
Yeah.
So can
It's
you
not
can you talk to the seller and say, look, we prefer not to work with a unrepresented buyer. Are you allowed to say that to your seller?
I'm not sure, you know, I would choose my words carefully, but you could tell the seller, you know, an unrepresented buyer, you know, your opinion, you don't want to make an affirmative statement. In my opinion, you know, brings a certain amount of risk because nobody's going to be guiding this buyer. Nobody's going to be telling the buyer to review. No one's going to be reviewing, for example, nobody's going to be reviewing the physical inspection with this buyer. And the buyer's going to close escrow and then go through that physical inspection and find the problem that he should have found while you were in escrow. But a buyer doesn't do that, but a buyer's agent could. So there are some risks there. So you know, so now what you're getting is you want the seller to say to you, well, I don't want unrepresented buyers to buy my house. Unrepresented buyer is not a protected class. So you can discriminate against buyers who are not represented. You want to be real careful because if that represented buyer is a member of a protected class, you want to make sure you're very, very careful in you know, the seller is requiring all buyers to have representation. And I would be careful to make you that representative because it sounds like it's self-serving.
Well, I just want to say I agree with Rick. I mean, it is, I think that, you know, sending over a RR or, you know, any of the documents, I mean, they're always going to have questions or they're going to have issues and they're going to come to you and say, what, I mean, you can't guide them. You can say, fill it out. I wouldn't even send the RR. I mean, if that buyer is unrepresented, why would I be, you know, saying, hey, it's, you know, send a request for repairs? I mean,
well,
I think you have to, it is such a fine line between, you know, guiding a buyer. I mean, because you're just saying, here's the paperwork, good luck. And if you don't think a buyer, and we've all been in this situation, by the way,
right.
well, I have. And so I think it is without a doubt, a situation that we have to guide these buyers into, okay, so let me tell you what this involves. If they say I want to be unrepresented, I think it is our job to let them know, oh, by the way, there are over 65 pages of disclosures that you will be reviewing and identifying and, kind of going through the process to educate them on, what they're going to be doing. And it's going to happen a lot. I mean, this is going to happen a lot. So Rick, thank you for asking that question. And I absolutely agree that that's not going to be an easy transaction.
Hence you have additional
Especially for free.
compensation. You have an additional compensation field. And aside from the dollar time spent, it's going to take you more time. There's no doubt about it. There's also greater risk because you're going to have to be very careful not to cross that representation line. And let me clarify, I probably spoke too quickly. I think in reflection, I probably wouldn't send them the RR outright. I'd probably tell them, all right, you need to tell me what repairs you want made, period. I mean, send me an email. What do you want? And then maybe you type it in and then send it back to them per your request. This is what I typed up. Is this what you want? You want to document that this comes from them. No, one would hope, but hope's not a strategy. One would hope that buyers don't, on a large scale, decide they don't need agents. I think what buyers are going to do more likely than buy unrepresented is be very open to dual agency. They're going to go to listing agents. Those of you who have listings and are open to dual agency, I think you're going to find that you're selling more of your listings because the buyer will say, well, I can't do this, but I don't want to pay a buyer's agent. Can you represent me? Well, there's a fee for that. Yeah, I can. And you'd sign a buyer representation agreement, but it'd be a dual agency or situation. Next question.
If an agent asks the seller to pay 5% for a listing, can the agent take half of that to pay the buyer's agent?
Yeah, you got to be careful how you
Or is
do
it illegal?
Yeah, you got to be, it's not illegal yet, but you got to be sort of careful how you do that. And there are no car forms that will support that in any way. Is it illegal for a buyer's agent to give 2% to the buyer? I mean, the seller's agent to give 2% to the buyer's agent out of their commission because they collected, 5%? No, it's not illegal. You just have to be careful how you offer that, how you condition that. It's not a road. Here, my little speech at the beginning, one of the reasons for it was to help you begin to get comfortable with the fact that the way we did things, we had all the right intentions. It worked beautifully. Cooperation among agents and knowing you're going to be paid and not having fair housing issues, all of the benefits of that. The intent is, nobody intended to collude to fix commissions. That wasn't our intent. The problem is that's not how the law is read. And even worse, the courts have been pretty strict. And that is if it has the appearance, it's per se price fixing. It's price fixing. So, Carr initially put out these forms with co-op compensation saying, yeah, we can do it. There's nothing against the law. They were convinced by the powers to be that is not the road you want to go down. That's not the wave of the future. So we're going to have to get used to the fact that buyers and buyers agents are going to have to figure out how they get paid, and sellers agents are going to figure out how sellers agents get paid, and sellers agents should recognize, certainly in California, that housing prices are so high that buyers are pretty tapped out cash wise, and they're going to be asking for help. You gotta work on your dialogues along those lines, and we'll help you with that. And again, the BCA is a good form to kind of study and then put in your own words.
Can you please go over section number 3, G1 and GH1?
Go over section D.
3G, like George. 3G1.
Oh, on the RPA.
Oh, okay.
Yeah. Okay, so 3G1 is all concessions not designated for a buyer's agent. Now, could you put that in that section? You probably could, but the problem is that 3G1 will be capped at whatever loan program the buyer's getting. So if the loan program only allows 2% concessions and you have a buyer representation agreement for 3%, you're going to get 2%, and the seller's not going to be allowed to pay the other 1%. You'd have to go back to the buyer for it. So 3G1 is for concessions other than buyer compensation. 3G3 is for concessions to pay the buyer agent, pay the buyer, so the buyer, they'll pay the buyer's agent on behalf of the buyer. And the reason 3G3 exists as a separate field, the benefit of it is that it will not be counted against seller concessions. Most loan programs cap seller concessions. So imagine this. Oh no, my loan program has 3% seller concessions. I'm only asking for 3%. That's covered. You put that in 3G1, and the repairs are a nightmare. And the seller says, tell you what, I'll give you $20,000. Oh my gosh, that's 1.5%, or that's 1%, whatever. Well, can't take it. The buyer can't take that credit because the seller said, no, the maximum credit you could have, maximum concessions you can have is 3%. And you put the commission in 3G1. So don't do that. Put the concession that is going to be used for the buyer agent payment in 3G3, because lenders will not count that against concessions. And now you've got whatever the loan program allows available to, pay buyer closing costs or pay for repairs, which we all know will be part of closing costs. I mean, it'll be added in, and you'll have that available to you.
What's the deadline by law for using the BRBC?
The deadline by law, I'll answer the question, is going to be January 1. The deadline for all NAR members, which all of you are, is August 17th. Keep in mind, individual agents have been sued. The NAR settlement covers you as an individual NAR member, so long as you don't violate the settlement. So any agent after August 17th who works with a buyer without a BRBC is not covered by the settlement. And, you got a long tail if you've been in real estate for 25 years. Any of those old buyers can come back and add you to the lawsuit. So you don't want to do that. I know it doesn't seem like a reach, but you don't want to be excluded from the NAR settlement because you're not practicing that policy. So the deadline for this office is unfortunately August 17th, unless NAR pushes it back. And the good news is everybody will have to do it starting January 1 anyway. So start doing it now. Get a couple of months ahead of your competition on how to do it.
As long as we can convince our seller to pay a buyer's agent's commission, why would a buyer request specifically to be unrepresented? Our service would be free to that buyer and our seller would be better protected. Am I missing something?
No, I think you make a great point. Now, here's why the buyer would think that. The buyer would think he's going to get that money. The minute you say, no, the seller is willing to pay 3% to cover your agent. I don't want an agent. I'm going to take 3% off my price. Same net to the seller. See that? For many of you on the call, you've had buyers come to you unrepresented to save the commission. The seller doesn't have to pay buyer's agent. What do relatives. I mean, I've done it. Some of you have done it. And we have this happen all the time. I have a license. I'm going to represent my son to buy a house. You don't need to pay me, but my son's going to buy it for 3% less. Okay. Well, the buyer got the 3% credit, and because he's related to the agent, he got the agent's services for free. See? But that's a concept buyers have anyway. Some buyers, I can save money if the seller doesn't have to pay a commission. So what you're missing, your logic is good. I agree with you. And that's what you've got to convince the buyer and the seller that it makes sense. But what you're up against is buyers are going to think if the seller's willing to pay 3% or 2% or whatever, he doesn't have to because I don't need an agent and I want that 2% concession on price or something like that.
This is also back to Rick's question. If the buyer has no one helping them, this agent only sees huge risks and E&O issues. An unrepresented buyer can tie up the property and make the transaction a nightmare. Can you even reach out to a buyer's lender to ask questions about their financial situation and proof of funds? I think we should have a recommended disclosure as a company.
Well, the RPA already gives you the right to reach out to the buyer's lender. They have to provide proof of funds anyway. Some agents do write in RPA that the buyer will instruct their lender to fully cooperate with listing agent to keep them informed of the status of the loan. So there may be some things you want to write. I mean, I can look at that. The form that will go a long way to protecting you is the BNA, buyer non-agency. So anytime you have an unrepresented buyer, you're going to for sure want to use the BNA. And I'm not sure we can expand much beyond that. I can look at it and see, CAR's pretty smart. I have made forms in the past that CAR didn't have. One of them is the HOA advisory. Some of you have been with the old company for years and years and years. You knew that we had one. We had an inspection waiver years ago before there was an inspection waiver. We had a walkthrough years before there was a walkthrough. In every instance, when CAR came up with one exception, and it's just different, I have a vacant land advisory that I created. It's 2 pages and it's lots of lines are filled up. CAR's vacant land advisory is not as detailed in some areas, more detailed than others, but I'm getting off the point. Every form CAR's ever come up with has been better than any form we've created. So don't discount the value of the BNA. That goes a long way to protecting you. And then you have to protect yourself by recognizing, do not give advice. You got to have this dialogue. I'm sorry, I cannot advise you. You should seek the advice of a professional that you trust, who's willing to provide it to you.
Okay, the next question is, can we put in the MLS remarks that the seller does not want unrepresented buyers so that it's visible to them in the online portals such as Zillow?
I'm going to check on that. I will see if that's allowable. We'll have to come up with the right words. There could be some problems with that. So let me find an answer to that. But I already made a mental note in the discussion with Rick and Kay, and just recognizing like some of you would just as soon like to convince your seller not to accept unrepresented buyers. And so I thought to myself already, okay, how do we memorialize that? And then whether we put that in the MLS or not, how can we do that? So I will defer an answer to that question till I research that.
Just to confirm, if I have a listing and I'm acting as a dual agent, the compensation will be based on the BRBC with the buyer, not the RLA anymore. I see C2 is for the buyer unrepresented, but not dual agency.
No. Let me. You're trying to blend two things together. In dual agency, you're going to have 2 commission agreements. you're going to have a listing commission agreement. And that field is going to be the seller's payment to compensate the listing agent. You're going to also have a BRBC. And that field is going to be the buyer's payment to compensate the buyer's agent. Now, on the buyer can ask the seller to pay it. So the seller is going to pay pursuant for the buyer. The seller is going to pay for the buyer pursuant to a BRBC. So the seller will pay 3% for the buyer because you have a 3% BRBC. The seller will pay you 3% because you have a 3% RLA or whatever percent you have. So could be 2.5%, whatever. So it's not, the BRBC does not replace the RLA as far as compensation in dual agency. It's a second compensation document. You would send, theoretically, most escrows don't ask you to send it, but theoretically you would send 2 documents to escrow. Here's the BRBC, charge the buyer 2.5%. Here's the RLA, charge the seller 2.5%. Does that answer the question? I don't know who asked it, but.
Yes, it was me, Walter. It was Vicky. Yes, that's what I basically was saying that. So it's going to be the listing agent and the RLA commission, and then the BRBC for the buyers.
Right. So you can't be a dual agent after the 17th of August without a BRBC.
Okay.
And that BRBC is going to be how much the buyer's obligated, and the buyer can ask the seller to pay it. But it doesn't negate the seller still obligated to pay you the listing side.
Oh, yes, I understood that.
RLA.
Yeah.
Right.
Okay, thank you.
Can the compensation for the unrepresented buyer that we put on the listing contract go toward representing the buyer?
Well, it wouldn't be unrepresented buyer then. So you would have a BRBC, and the buyer would pay that, and then you wouldn't have an unrepresented buyer. Sort of semantics, but so let's say you have a 2.5% listing and you have a 2% unrepresented buyer clause. I want 4.5% if this buyer is going to buy it and he's not represented. All right, but now the buyer wants to be represented and he's willing to pay you 2%. Well, you're not going to get the 2% for the unrepresented buyer. You're going to get 2% from the buyer for representation and 2.5% from the seller for representing the seller. That make sense? Whoever asked the
It
question.
was Sissy.
Yes, it makes sense, but I was wondering, at least for sellers' mindset, as long as they're willing to pay certain percentage toward unrepresented buyer, at least that way they're their mindset says, okay, I'm going to pay a buyer who wants to pay their agent. And if it's a dual agency, it might be easier to just get acceptance on that from the seller. Can it be converted?
I think, Sissy, you're touching upon excellent dialogue. So you talk to the seller, okay, I want 2.5%. And by the way, this is a very complicated process. And if I'm going to have to work twice as hard if the buyer is unrepresented. So I'll tell you what, I'll give you a discount. I'll only charge you 2% if the buyer is unrepresented. Okay. Now, but keep in mind, seller, are you okay with that, seller? Yes, I'm okay with that. Great. You wouldn't object. No, I wouldn't object. Great. Now, keep in mind, if the buyer is represented, since you're willing to pay me 2%, if the buyer is unrepresented, would you not be willing to pay 2% on behalf of the buyer? And then, help make that correlation. The seller should say, yeah, that makes sense. So yeah, I think you've stumbled upon great dialogue to, number one, protect yourself if you end up being stuck with an unrepresented buyer, but opening the door for somebody who's agreeing to pay you extra. Well, just because the buyer's represented, don't throw that money away. Keep that in mind. Give that to the make that available to the buyer's agent, on behalf of the buyer. I like your thinking, Stacey.
Thank you.
This is the final question. If a buyer's unrepresented, does the listing agent write the RPA? And if so, isn't that a risk of implied agency?
That's a great question, by the way. And Carr actually feels like you could write the RPA. I have a question out the car. They haven't answered it, but I have done this in the past and I've taught this in the past. You can reverse the order. There's nothing wrong with a seller offering to sell the home with 17 pages of terms. So the seller signs the RPA and the buyer accepts it. If the buyer doesn't like the RPA, the buyer counters the seller generated RPA. So you could do that as well. That's a little more complicated. And Carr has said, no, if you write the RPA, what you want to do is you want to, and again, I agree with Rick. I'm not sure I'd like to send blank forms off, but my thought is you maybe copy the pages on the grid and you say, you need to tell me what to put in these blanks, as opposed to retyping it all up and asking questions. You know, and so the buyer tells you what to write in the RPA, and then but if you actually wrote the RPA and documented that this RPA is being prepared at the direction of the buyer with no counsel or advice from the agent, and is being done to facilitate the sale of the property for the benefit of the seller. Maybe I'll get some language and put that together for you. But I think writing an RPA per se does not create implied agency. It could if you do other things, like start advising, sending him a list of inspectors, telling him, you know, what he should ask for, reviewing the physical inspection with him, and pointing out some things that they may want to have inspected further. You know, no, that's up to the buyer. See, the seller's never going to sue you because the buyer didn't get additional inspections. Buyers do because you represent the buyer. So the physical inspection recommends the buyer to get physical inspections. As a listing agent, you have zero duty and almost zero liability to recommend those inspections to a buyer. See, so you do not need to review the physical inspection and advise the buyer what to do with this stuff. The minute you do, now you're assuming agency, and that could get you in trouble.
Well, I think the moral of the story
Yeah.
is if you put a number you're comfortable with and that representing a non-represented, or not representing, but working with a non-represented client, that's what you should do to protect yourself. That number better be significant, is in what I'm hearing from this.
Yeah, Rick, you didn't quite say this, but I think the implied, I'll go ahead and say it outright. You make that number high enough, the seller's going to say, great, we're not going to have any unrepresented buyers in this transaction because I don't want to pay that much.
Well, just make it worth your while, I guess is what I'm saying.
That's exactly right.
Anyhow, all right.
Yeah.
That'll-
We could all sadly discover that this is going to be a huge problem. Carr, in several conversations, they believe that the number of unrepresented buyers will go up, but not nearly as much as dual agency will go up. And I'm right now sort of thinking that, although you as a group are making me think, you know, this unrepresented buyer may be a real big problem. You know, I mean, big by sheer volume. It's big, even if you have one, it's a problem. You got to be so careful.
Hey, Walt,
Yes.
what about land contracts, commercial contracts? Are they all going to be changed too?
Yeah. The compensation is changing on all of the other purchase agreements and listing agreements.
Can you promise us that you won't update these things every 5 minutes?
Well, I apologize. I tried to get ahead of the curve, and the hard car kept changing the forms on me. They were changing them mid preparation. You know, I had one set ready to go, and then I'm putting it together, and they revised them. But I did want to get ahead of the curve with you folks as much as we possibly can. And you know, here's the good news. I mean, on day one, I think you've got a pretty solid foundation on the RLA, and you know, you're going to go out and take listings tonight, hopefully, and tomorrow and the next day. You need to know the RLA. a week from now, you'll have a pretty good foundation on the BRBC.
You're amazing, Walt. It's unbelievable
Thank
that
you.
forms they got updated today and we got trained on it. It's
Mhm.
amazing. Thank you.
So you guys, you make me, you inspire me. You
Mhm.
guys are a great group of agents. I couldn't be happier being helpful to you, because what you do is not easy and you're under siege. And I feel for you. There's a struggle with everything changing all the time. And my hat's off to every one of you for hanging in there and saying, we're going to weather this storm and we're going to come out on top.
Yeah, thanks, Walt. Change it as many times as need be, because we appreciate you doing it and we don't have to investigate it all on our time. So kudos to you.
Thank you so much.
Thanks,
Walt.
Walt.
You are just
Thank you.
amazing.
Thank you. Thank you.
Thanks, everybody.
Thanks,
you.
folks.
See you
Bye.
later.
If you have any questions.
Thank you, job security for Walt. Thank you.
That's true.